If you're the one person who hasn't watched The Secret Lives of Mormon Wives and doesn't know what's going on with Taylor Frankie Paul and Dakota Mortensen, let me catch you up. There was some incident in 2026 that led to both parties filing for mutual protective orders against each other. They also both went to their respective district attorneys and attempted to get the other charged with criminal charges. I'm Allie Moore with Cape Fear Family Law. This is general North Carolina legal information, not Utah legal advice and not legal advice for your specific situation. If anything you hear today sounds like your relationship, please reach out to the resources on screen. Here's what public reporting tells us, and only what public reporting tells us. On April 30th, 2026, Taylor and Dakota appeared in court, and after a hearing of about 2 hours, they both walked out with mutual protective orders against each other, requiring that they stay at least 100 feet away from each other for 3 years. Here's the important thing. The judge that day did not decide custody of their son Ever. Dakota still has temporary custody of Ever based on his initial filings. However, the judge specifically held open that issue and is going to issue written parenting recommendations by May 11th with a review hearing on June 1st. That's what's out there in the public record, and that's the only thing out there in the public record. Separately, in 2026, both prosecutors involved declined to file criminal charges. The Salt Lake County District Attorney's Office declined to file charges against Paul, citing statute of limitations issues and insufficient evidence. The Draper City prosecutor declined to file charges against Mortensen. That's it. That's the public legal posture. I'm not adding to it, and I'm not deciding it. What I'm going to do is translate what the legal pieces actually mean, using North Carolina law, because that's what I'm licensed to discuss. In North Carolina, a domestic violence protective order is governed by Chapter 50B of our general statutes. You'll hear it called a DVPO or a 50B order, same thing. 3 pieces of this matter for understanding what you see in the news. First, a DVPO is a civil order. It is not a criminal conviction. It does not appear on the defendant's criminal record. The civil burden of proof is the preponderance of the evidence. That's much lower than the criminal beyond a reasonable doubt standard. That means that the same set of facts can support a protective order even when prosecutors decline to file charges. Those are 2 very different legal lanes with 2 very different standards. Second, a final DVPO in North Carolina can last up to 1 year and can be renewed for up to 2 years at a time, multiple times, if the court finds good cause. So when you hear a court grant a 3-year protective order, like Utah did here, it sounds long, but it's roughly comparable to what North Carolina can build through a renewal system. Third, a 50B order can do far more than say stay away. A judge can address possession of the residence, temporary custody and visitation, firearms, contact restrictions, support, attorney's fees, and other safety conditions, all in the same order. That's why protective order hearings are high stakes and short fused. This is the part the internet keeps getting wrong, so I'm going to slow down. When a court grants protective orders to both parties, mutual orders, that does not mean that the court found them equally responsible. It does not mean both are guilty or that both are innocent. What it usually means is that the court found enough on each side to grant separation-based protection both ways, and concluded that the safest path forward was to keep these parties apart. 3 things matter here under North Carolina law. 1. North Carolina's domestic violence statute specifically excludes acts of self-defense. So, a mutual protective order in North Carolina is not built on both people defended themselves. It rests on the court finding qualifying conduct on each side beyond self-defense. 2. The standard is preponderance of the evidence. The court is asking whether it's more likely than not that qualifying acts occurred, not whether they're proven beyond a reasonable doubt. 3. Credibility, patterns, prior orders, and consistency all factor in. Courts look at the whole record, not just one moment. So when somebody online says, mutual orders prove they're both equally bad, that's a comment section conclusion, not a legal one. The cleaner read is, the court believed separation was the safest immediate outcome, and the longer questions, like who did what happens with custody, what happens with criminal exposure, go to other proceedings with other standards. Here's the part I want every parent to hear clearly. In North Carolina, when a court is considering temporary custody or contact in a 50B protective order case, the court is required to focus on the safety and well-being of the child and the protected party. A 50B order can include temporary custody, but here's the limit most people don't know. Temporary custody under a DVPO cannot exceed 1 year in total duration. Anything beyond that has to come from a separate custody proceeding under our regular custody statutes. Translation for the Utah case, the protective order is one track. Long-term custody of their 2-year-old son is a separate track. That's why the commissioner there is still working on parent time recommendations, even after the protective orders were entered. North Carolina works the same way conceptually. Protective orders for safety now, custody for the child long-term. And in that long-term custody analysis, the controlling standard in North Carolina is the best interest of the child. That standard is gender neutral. It looks at stability, safety, the relationship between the child and each parent, history of caregiving, exposure to conflict, and a long list of practical factors. If alleged domestic violence is in the picture, the court can absolutely consider it. The court can order supervised visitation, third-party exchanges, supervised exchange centers, and other safety conditions. None of that requires a criminal conviction first. It requires evidence that the court finds credible. If something in this story is hitting too close to home, please hear the order of operations. Step 1, safety. If you are in immediate danger, call 911. If you need confidential support, call the National Domestic Violence Hotline at 1-800-799-7233 or visit thehotline.org. Free, confidential, 24/7. You don't have to know what you want yet. You just need to be safe tonight. Step 2, documentation done legally. Texts, voicemails, photos, medical records, police reports, save them. Back them up. Don't violate any existing orders to gather evidence. That creates new problems and undercuts your case. And please, do not try to litigate the situation on Instagram or TikTok. Captions become exhibits. Stories become impeachment material. The court can read your post too. Step 3, strategy with a North Carolina attorney. 2 timing notes most people don't know. First, North Carolina absolute divorce requires you to be separated for 1 year and at least one spouse to have lived in North Carolina for 6 months before filing. That's the divorce clock. But you do not have to wait a year to address safety. A 50B can be filed today, and an ex parte temporary order can issue the same day in emergencies. Second, if there's already a protective order against you, take it seriously. Read it. Don't text. Don't show up. Don't send a friend or a family member to deliver a message. Don't comment on their posts. A 50B violation in North Carolina is a Class A1 misdemeanor, and law enforcement is required to arrest on probable cause, meaning they don't even need a warrant. No contact means no contact. Here's what I hope sticks from all of this. Mutual protective orders are not a shortcut. A protective order is not a criminal conviction. Domestic violence under North Carolina law is broader than visible bruises. It includes fear of imminent serious bodily injury, continued harassment causing substantial emotional distress, and certain sexual offenses. And when children are exposed to alleged domestic violence, the court's focus tightens on one question: what arrangement best protects this child? Public stories like this are useful because they're already in the open. They're not useful as scoreboards. The Paul Mortensen case will continue to develop in a Utah courtroom on its own evidence, on its own timeline. My job is not to score it. My job is to make sure that if this story makes anyone in North Carolina recognize their own life, they know what the law actually offers and what the smart next steps look like. If anything in this video sounded like your relationship, please use the resources on screen first. If you're in North Carolina and you need to talk to a family law attorney about a protective order, custody, or separation, Cape Fear Family Law has offices in Wilmington, Durham, and Jacksonville. Link is in the description. I'm Allie Moore. Stay safe out there.